Professor Ting, if you would start us off.
Thank you, Mr. Chairman, and members of the Commission. I'm grateful for the invitation to speak today and discuss these issues with you and with my distinguished colleagues on this panel. As the Supreme Court has stated, over no conceivable subject is the legislative power of Congress more complete than it is over the admission of aliens. Our cases have long recognized the power to expel or exclude aliens as a fundamental sovereign attribute exercised by the government's political departments, largely immune from judicial control. In the exercise of its broad power over naturalization and immigration, Congress regularly makes rules that would be unacceptable if applied to citizens. The exclusion of aliens and the reservation of the power to deport have no permissible counterpart in the federal government's power to regulate the conduct of its own citizenry. In the exercise of its plenary power over immigration, Congress has enacted the most generous immigration policy in the world. By direction of Congress, we admit each year to the United States more legal immigrants than all the rest of the nations of the world combined. But the number is limited through complex preferences that I describe as a pick-and-choose system. Those not chosen but who come anyway or who overstay their temporary visas are subject to removal. Congress has delegated administration and enforcement of its immigration laws to the executive branch of government. Removal of illegal aliens is exercised administratively, with only limited appeal to the federal courts. Prior to 1983, designated officers of the Immigration and Naturalization Service itself ruled on the immigration charges brought by the INS and issued the removal orders. Only in 1983 were those officers transferred from the INS to a separate branch of the Department of Justice where they remain today. These immigration judges are not members of the judiciary. They work for the Department of Justice and for the Attorney General. Removal of illegal aliens from the United States is not criminal punishment. Procedural rights of criminal defendants do not apply. Aliens in removal proceedings are not, for example, entitled to jury trial. They're not entitled to lawyers paid for by the taxpayers. They cannot invoke the exclusionary rule against their removal. Detention is a common part of the removal process and perhaps should be more common than it is now. Americans are no longer surprised to hear that there may be as many as 10 million illegal aliens in the United States. They are astonished, however, to hear that more than 300,000 of those illegal aliens have actually been caught by the INS, taken before immigration judges who have ordered their removal, exhausted all their appeal rights, and then simply absconded and remain in the U.S. despite the outstanding removal order. The explanation is that these aliens were not detained, but were released on bond pending the final resolution of their cases. We're all aware of the June 2nd report of the DOJ Inspector General on the treatment of aliens held on immigration charges in connection with the investigation of the September 11th attacks. The IG expressed concerns about delays in the issuing of charging documents, the FBI clearance process, actual removal from the U.S., the INS's no bond policy, and conditions of confinement of the 762 detainees studied. The IG's concerns have been accepted in principle by the Departments of Justice and Homeland Security, and negotiations seem to be continuing on the best ways to address those concerns. As Professor Martin notes in his written testimony today, the Immigration Service's bond determinations have always been subject to review, and the government's ability to stay an immigration judge's bond determination has always been provisional, pending outcome of appeal to the BIA, the Board of Immigration Appeals. Professor Martin found the DOJ's initial response to the IG's concerns to be dismissive, but I thought it properly noted the absence of any finding by the IG, after careful investigation, of any violations of law by the Immigration Service in the unprecedented and extraordinary circumstances following the 9/11 terrorist attacks. It also clearly articulated the DOJ's legal positions, that the government can use the full statutory 90-day period to remove an illegal alien, that it can take more than 90 days if the delay is to investigate ties to terrorism, that release of an illegal alien on bond is discretionary and not a right, that experience demonstrates that illegal aliens who are not detained usually flee and avoid deportation. One concern I had about the IG's report was regarding the allegations of physical and verbal abuse at the Metropolitan Detention Center in Brooklyn, New York. If these allegations have substance, the dismissal and prosecution of the offending employees ought to be forthcoming. Exemplary punishments, if warranted, would serve to protect the rights of future detainees. The IG has promised a further report on these allegations. The IG did not express concern about the DOJ's decision to conduct closed immigration removal hearings for special interest aliens charged with immigration law violations without disclosure of the information to the public. We have had conflicting decisions from the Sixth and Third Circuit Courts of Appeal on First Amendment challenges to this policy. I much prefer the decision of the Third Circuit sustaining the DOJ policy, which found a basic tenet of administrative law is that agencies should be free to fashion their own rules of procedure, and required consideration of the extent to which openness impairs the public good. In the interest of time, I've tried to limit this statement to the use of immigration law to detain and remove illegal aliens after 9/11, but I can't let this opportunity go by without asking the Commission, in pursuit of its mandate to make recommendations to prevent further terrorist attacks, to also consider other national security issues related to immigration. First of all, the need for a more foreign language capability is well known now. Why isn't there a program in place to remedy the foreign language gap? In the 1960s and 70s, we had the National Defense Foreign Language Act to encourage young Americans to study what were then critical languages, and I was one of those beneficiaries. Why are our borders still as open as they are? Every night since 9/11, hundreds of illegal aliens succeed in surreptitiously entering the United States, and we have no idea who they are. We read only about those who are caught or who die in the effort to enter. Why is enforcement of the law against employment of illegal aliens dropped precipitously? And I cite some statistics in my statement. Besides considering what changes in law and policy to recommend, please also consider the extent to which simply enforcing the laws on the books can enhance national security and protect us from further terrorist attacks. Thank you.